Hello, I'm Judge Yu. I'll be taking you on a tour through the courthouse and showing you how to get your case ready for trial.
And I'm Judge Gonzalez. I'll be highlighting the courtroom procedures once you've filed your paperwork and are ready to appear for court. You should know that any time during this video you can push pause to jot down helpful information. First, make sure you go to the right courthouse. There are 3 locations where King County Superior Court holds sessions. The courthouse located in downtown Seattle on 3rd and James, the courthouse in Kent on 4th and James, and the courthouse located in Seattle in the central area on 12th and Jefferson, where cases involving juveniles are heard. Today, we'll be showing you the inside of the Norm Mailing Regional Justice Center in Kent. It's known as the RJC for short.
A lawsuit usually starts when you serve or are served with legal papers called a petition or a complaint. On these legal papers, you will find what's called the case designation. It tells you in which courthouse the case was filed and where your case will likely be heard. Be sure to read all of the papers that are given to you so that you know how to respond. When you first file a case, you will get a case schedule. It outlines all of the deadlines and tells you the name of the judge who has been assigned to your case. Being involved in a lawsuit is not easy because of the rules and procedures. You should try to get a lawyer to assist you. There are many resources available.
Hi, I'm calling because I'm trying to take a case to court for modification of child support. I need to know if you give free consultations.
If you are unable to get an attorney or wish to proceed on your own, also known as appearing pro se, there are self-help resources you should know about that will be discussed in this video. Once you know which courthouse to go to, it is important to know how to navigate through the courthouse. Here at the RJC, there's a map hanging on the wall before you go through security. Reviewing this map is a great way to get acquainted with the courthouse, and it can help you find where you are going if you already know your courtroom assignment. The first thing you need to do every time you enter the courthouse is go through security. Be sure to allow plenty of time. Courthouse security is much like airport security. You will need to place any bags on the conveyor belt and remove any metal from your pockets before passing through the metal detector. Here is a list of things that you may not bring into the courthouse. The clerk's office is where originals of all of the papers for a case are filed. It is here that you can look up your case and see the documents that have been filed. If English is not your first language, or if you are in need of a device to help you hear, or you would feel more comfortable with a language or sign interpreter, you should contact the interpreter's office. There are over 100 foreign languages utilized in King County. The Family Law Information Center has various forms you can buy to use in a family law case. Although the staff cannot give you legal advice, they can provide information and referrals. The courthouses also have law libraries where you can do legal research. You can use their computers to access helpful self-help legal websites like washingtonlawhelp.org. Now that you have an idea of the resources available to you, let's talk about how to prepare your legal paperwork and make sure that it gets to the judge in your case. Once your paperwork is complete and ready to turn into the court, make at least 4 copies, 2 for the court, 1 for the other party in the case, and 1 for you. You can make copies in the law library or at the clerk's office for a small fee. After making copies, you should go to the clerk's office and turn in or file your original paperwork there. If you are just starting a case, you should go to the counter and show your paperwork to the clerk. The clerk will give you a form to fill out so the court knows what kind of lawsuit you are starting.
That'll be $200.
The clerk will then tell you how much it will cost to file the case. Filing fees can range from $20 to $250 or even more. If you are low income or if there are circumstances that make you unable to pay at the time, you can ask the court to reduce or waive the filing fee. Ask the clerk for a fee waiver form.
Thank you. Bye.
After you file the correct legal paperwork to start a lawsuit, you must then have a copy of the legal paperwork served on the person or entity you are suing and provide a copy of your complaint. There are special rules for how to serve the other party, so you should make sure you read Court Civil Rules 3, 4, and 5. You can ask the law librarian for help with finding these rules. If you are not the person who started the lawsuit, but instead you are trying to respond to a lawsuit or defend yourself, you must respond to the complaint in writing. Generally, you have 20 days to respond, but the timelines may be different depending on the circumstances. You should file the original of your written answer or response at the clerk's office, and also send a copy to the opposing party or her lawyer if she has one. You should consult an attorney or review Civil Rule 12. Once the lawsuit has started, you may want the judge to decide an issue in the lawsuit that cannot wait until trial. The only way you can communicate with a judge is in writing. Communicating with a judge is done by filing what is called a motion. When you are preparing your motion, you should write what you want, why you want it, and the reasons why the judge should grant your request. If you have any supporting documents, receipts, or photos, you should attach those to your motion. If you also want to submit statements from witnesses, you should make sure that they are signed under penalty of perjury of the laws of the state of Washington. When you finish writing your motion, you should then fill out a form called a note for motion. That serves as a transmittal sheet. This is the form you will use to schedule a date for the judge to hear your request and let the opposing party tell his or her side of the story. To get this form, you can download it from the court's website or ask the law librarian or other self-help resources. You should review the King County local rules, particularly Local Rule 7, so you know how to file a motion. After you are done writing your motion and completing the note for motion form, you should make copies and file the original at the clerk's office. After filing the original with the clerk's office, you should then file another copy for the judge to review. This copy is called working papers, and it must be delivered to the judge's mailroom. Before filing it, you should write in the top right-hand corner of the motion the judge's name and the date you scheduled your motion to be heard. If you are filing a motion in a family law case, like a divorce, a family law commissioner will decide whether to grant your motion. You should stop in and see someone at the family law facilitator's office for help with making sure you know how to schedule and confirm your motion hearing date.
After filing the original motion and supporting paperwork with the clerk's office and the judge's mailroom, you must also send a copy to the other parties in your case. After personally serving the summons and complaint, you can mail a copy of the other paperwork as long as you give the person enough time to respond. You should check King County Local Rule 7 to determine any deadlines. Now that you are done with preparing, filing, and serving your paperwork, you can prepare for appearing in court. You should check your court papers to confirm any dates and times you need to be in court and verify the location. You might need to appear in court for a hearing you or the other party scheduled for a motion. You might need to appear in court for what's called a status conference, when the court wants to check in with you on the case, or for a settlement conference. If the case doesn't settle, you will need to appear in court for the trial. When the date has come for you to appear in court, remember to plan ahead and leave plenty of time to take the bus, and if you must drive, to find parking and the right courtroom. Some people get nervous when speaking in front of a judge. To be prepared, you should make sure to bring copies of your court documents, a proposed order, a written outline of what you want to say, and pen and paper to take notes. If you are appearing for trial, you should make sure that you have organized your evidence in advance. Examples of evidence are a photograph, a police report, or medical records. Exhibits are the proof that you will offer to the judge of your claim. For example, if you are contesting a bill, make sure you bring copies of the bill that is at issue. You should have 4 copies of your exhibits: a copy for you, a copy for the other side, a copy for the judge, and a copy for the clerk.
Are the parties ready to proceed in the matter of Gomez versus Johnson?
You should stand when you address the court.
Yes, Your Honor.
Yes, Your Honor.
The judge will invite the parties to explain what they want the court to decide. Be sure to address the court directly, not the other party. Generally, the person who requested the hearing will speak first.
Your Honor, I'm here today to ask that the court consider my request for modification in child support.
Then the other party will have a chance to speak and respond.
No, Your Honor, I'm not in agreement.
Afterward, the person who spoke first will get a chance to reply to the other party's response. When the other party is arguing, it helps to take notes of what you want to say in response to the judge. The judge may ask you questions while you speak. It is important to listen carefully to the judge's questions and answer with truthful answers.
No, Your Honor.
Remember to address the judge as Your Honor. If the judge asks you questions that you do not know the answer to or can't remember fully, tell the judge, I don't know or I don't remember. Don't guess. If you are appearing in court for a trial and are presenting exhibits, you should give the exhibits to the clerk in the courtroom so that he can mark them with numbers. Then ask the judge to admit the exhibits. The judge will determine whether she can consider it under the law. If so, the judge will admit it into evidence and consider it as part of her decision-making.
Those will be exhibit number 2.
When you and the other party are finished arguing to the judge, and the judge does not have any more questions,
All right.
she will usually make her decision and let the parties know.
I find, based on the support calculation, that an appropriate amount of child support.
When the judge says her decision, it is up to the parties to take good notes. The parties then take those notes and put them into the form of an order for the judge to sign.
This concludes our tour of the King County Superior Court and highlights of representing yourself in a lawsuit. We invite you to look at our website for links to self-help information and legal resources.